Worker misclassification. For a company seeking to control labor costs or manage its workforce to account for fluctuations in the business cycle, classifying workers as independent contractors can appear an attractive option. Since independent contractors are not considered employees, they are typically not entitled to employee benefits, overtime compensation, unemployment benefits, or workers' compensation benefits in many states. Employers may choose to classify workers as independent contractors even when the situation does not really support that designation, driven as they are by the desire to avoid these extra costs and potential liabilities. The ambiguous and uneven criteria for classification mean that even well-meaning employers risk misclassifying workers as independent contractors. However, the costs associated with this kind of misclassification are rising. In the last several years, numerous federal and state agencies, including the U.S. Department of Labor, DOL, the Internal Revenue Service, IRS, and the New York State Department of Labor, NYSDOL, have stepped up their enforcement efforts regarding the misclassification of independent contractors. Federal scrutiny. In 2010, the DOL and the IRS announced an initiative aimed at identifying employees misclassified as independent contractors. The agency has identified several high-risk industries for increased independent contractor misclassification investigations, including construction, home health care, transportation, and warehousing. For its part, the IRS aims to audit 6,000 business enterprises each year in order to identify misclassified employees. The DOL and IRS also have announced a carrot-and-stick approach with respect to worker classification issues. The IRS recently unveiled the Voluntary Classification Settlement Program, which allows employers to elect to treat workers as employees in future tax years. In exchange, the IRS will waive all but a small portion of past tax liability, including all penalties and interest that might otherwise be assessed. The program is not open to employers who are currently under audit by IRS, DOL, or any state agency regarding worker classification. At the same time, the IRS and DOL also have established a joint information sharing program designed to target employers who do not participate in the settlement program. The DOL will provide the IRS with investigation information and other data that DOL believes may raise Internal Revenue employment tax compliance issues related to misclassification. IRS will examine and classify employment tax referrals provided by the DOL and then determine compliance with employment tax laws. The IRS also will provide the DOL with aggregate data relating to trends in misclassification on an annual basis. The DOL also has entered into written information sharing agreements. State scrutiny. Worker misclassification has been a growing target for state governments as well. In 2007, New York established the Joint Enforcement Task Force on Employee Misclassification, creating a partnership between the NYSDOL, the New York State Workers' Compensation Board, the New York State Workers' Compensation Fraud Inspector General, the New York State Department of Taxation and Finance, the New York State Attorney General's Office, and the Comptroller of the City of New York. The purpose of the task force is to increase information sharing between these agencies and to better coordinate their misclassification investigations and enforcement efforts. As of February 1, 2011, the task force had conducted 79 joint enforcement sweeps, identifying $205 million in unreported wages, more than $5 million in unemployment taxes due, more than $7 million in wages due, and approximately $2.3 million in workers' compensation penalties. 4 In certain cases, JETF investigations also have led to criminal prosecution for falsification of business records and violations of tax law, among other offenses. Employers in the construction industry have become a special target of state legislation. In 2010, New York passed the New York State Construction Industry Fair Pay Act, which creates a presumption that workers utilized by construction contractors are employees rather than independent contractors. 6 Studies leading to the passage of the Construction Industry Fair Pay Act purportedly found that as many as 1 in 4 New York City construction workers were either misclassified as independent contractors or employed completely off the books. Private scrutiny. The misclassification of independent contractors also has become an increasingly popular target for the plaintiffs' bar. Many such challenges have been brought under the overtime and minimum wage laws, including the Federal Fair Labor Standards Act, FLSA, and analogous state laws. Plaintiffs have brought class lawsuits challenging the classification of financial advisors, field nurses, sales assistants, and a host of other workers. Plaintiffs and the DOL also have brought actions seeking employee benefits for workers classified as independent contractors. For companies utilizing many independent contractors, the scope of potential liability for these claims can be significant. For example, FedEx has been engaged in a decade-long challenge to its independent contractor model, with more than 27,000 drivers alleging that they were misclassified under the FLSA and the wage and hour laws of 40 states. While FedEx has been able to get some of these state law claims dismissed, the court refused to dismiss the plaintiffs' claims under the FLSA and under several other state laws. In addition to claiming violations of the wage and hours laws, plaintiffs also have brought such challenges as tort claims, breach of contract claims, and claims of unfair trade practices. In Harris v. Vector Marketing Company, for instance, plaintiffs coupled their FLSA claims with an argument that the defendant engaged in unfair competition by misclassifying workers as independent contractors and depriving them of overtime wages and benefits. Vector ultimately settled the action for $13 million. Plaintiffs even have alleged misclassification claims as violations of the Racketeer Influenced and Corrupt Organizations Act, RICO. Unions also have targeted employers for misclassifying workers as independent contractors. In OS Transportation LLC, for example, the company told its workers that it was futile to join a union because they were independent contractors and not employees, as defined under the National Labor Relations Act. The Teamsters Union challenged this conduct, arguing that the workers were employees, and that the company's statement formed an unfair labor practice. The NLRB agreed with the union that the workers were misclassified, and that the statement was intended to discourage employees from the exercise of their rights. Conclusion: the DOL, IRS, state agencies, legislatures, and plaintiffs' bar have all increased their scrutiny of the classification of workers as independent contractors. Ingenious strategies are still being employed by organized labor and the plaintiffs' bar to pursue lawsuits on behalf of employees who are categorized as independent contractors. Businesses using independent contractors should carefully consider the legal requirements for this classification and how they apply to prevent lawsuits and potential liability. Businesses should also think about being proactive in limiting their possible liability if it is discovered that their employees have been misclassified.